prosecuting authority has confirmed today it's going to prosecute the leader of the ANC Women's League, Bathabile Dlamini, for allegedly lying under oath while she was the Minister of Social Development. The Constitutional Court found that she had neglected her duties during the social grants payment scandal. A separate inquiry then chaired by Judge Bernard Ngwepe found that she had lied about her role in the scandal. She lied under oath. Ariella Scher is at the Centre for Applied Legal Studies, one of the organisations which has been involved in this case and monitoring the situation. Ariella, good afternoon to you. What kind of prosecution is Bathabile Dlamini now going to face?
Hi, Stephen. Thanks so much for having us on. Yes, so as you've mentioned, it emanates from the inquiry undertaken by Judge Bernard Ngwepe and then referred to the Constitutional Court. And what Judge Ngwepe found was that it was very likely that former Minister Dlamini had been evasive and had potentially even lied under oath when presenting evidence to his inquiry. So the charge that we've been advised that the former minister has now been summoned to court under is a charge of perjury, which is for lying under oath, alternatively for presenting incorrect facts to that inquiry.
I would imagine this is not a complicated charge. There's the testimony she gave under oath. There'll be a record of what she actually did in the department. Most of that stuff is written down, their emails and things. So I'd imagine it's quite simple to make a determination about whether she's guilty or not.
Thanks, Stephen. Yes, well, we at the Centre for Applied Legal Studies, on behalf of the Black Sash Trust, we have actually been following up with the NPA since that judgment was handed down in September 2018, because as you've just said, we thought that it would be quite a simple matter to determine whether they wanted to prosecute. And we were actually only informed towards the end of last week that they've now taken the decision. So their investigation has come to this decision. But we are in support of the prosecution, and we do believe that there's more than sufficient evidence to hold her accountable.
So we have a judge that says, I think that she lied under oath, or she may have lied under oath. It's taken the NPA 2 years to get to this point?
September 2021 until, September 2018 until September 2021. That's almost 3 years.
Sure. Perjury is a serious charge. It would be a first offence. I don't know. Would she serve jail time? I can't imagine that.
Stephen, so perjury is a common law offence, so there isn't a minimum sentence applicable to perjury. So we don't want to make any assumptions about if she were to be found guilty, what the judge would hold her accountable for in terms of a sentence, whether it would be jail time or a fine. It is, though, a very serious offence, and I think that we at Carlson Black Sash believe that it's compounded, the seriousness of the offence is compounded by the fact that she was a minister in the cabinet, and she was giving evidence at the inquiry and which was referred to the Constitutional Court in her position as minister. So definitely there are militating circumstances that might justify a more harsh sentence if she were to be found guilty.
Well, it's a landmark case in that way. It's a landmark case in other ways. I mean, she was a government minister. She was found by a court, and I'm probably being polite, to have conducted herself in a way which would mean people would not get their social grants. I mean, essentially, she seemed to do everything she possibly could to make sure that Cash Paymaster Services kept a contract. I mean, this was a company run by Serge Bellamont. This could set a precedent for what happens to other ministers in the future if they do this kind of thing while in office. And I suppose really it goes to whether she was acting in good faith or bad faith. A finding of perjury would mean she was acting in bad faith.
Yes, so in the first instance, this is a very important case because it shows, even though it's taken quite a while for the NPA to make the decision to prosecute, it demonstrates really that no one's above the law, that in the course of her conduct while acting as minister, that she performed something that might very well be a crime, and now she must be prosecuted. But more than that, I think it's worth highlighting the actual nature of her conduct. And what Judge Ngwepe found was that it was very likely that former Minister Dlamini had lied under oath or had presented false evidence because she felt that she was trying to avoid being held personally accountable for what she did. And what she did in relation to that tender given to CPS to conduct the payment of social grants was that Judge Ngwepe found that she actually instituted a parallel system. So within the DSD, the Department of Social Development's management processes, former Minister Dlamini actually put her own people in place and imposed parallel processes so that the CPS tender could be managed by her people, and we assume in the way that she wanted them to be managed, rather than in terms of the policies or the management structures that would have already been in place.
Ariella Scher at the Centre for Applied Legal Studies, do appreciate the time. Thanks very much indeed.